Okay, so welcome everyone to the February Resilience Business Continuity Leaders meeting, and today we have a very exciting presentation from Dawn Hutchings, which is all around considerations for small business owners around preparing yourself in terms of wills and lasting power of attorneys, and what we should all be thinking about as we go about our daily business in preparing ourselves and our colleagues and our organisation for the future. So I will hand over to Dawn and let her introduce herself and talk through the session.
Thank you, Helen. So I'm just going to share my screen, if that's okay. Let me know when you can see that. So it should just be, yeah, one screen of stuff. Okay, perfect. Right. So what can you see now? Just the one screen?
Just the introduction.
Yeah, okay, perfect. Yeah. All right, so it's hard to know, isn't it, when you're on multiple screens that you've got the right one. Okay, perfect. So I'm Dawn Hutchings. My business is Downs Legacy Ltd, and I'm a will writer and estate planner. So I work through the Society of Will Writers. So I'm a professional will writer as opposed to a solicitor whose remit might be much broader. I literally focus on wills, will trusts, and lasting powers of attorney, with some kind of tax planning in there as well. So that's my all day, every day. A little bit of background. So I started out in large corporates, doing sales support and IT, management, accounting, that sort of thing for brands like Andrex, and also up at Thales in Crawley, making flight simulators, things like that. Kind of random products. I then moved into financial services. So along with my husband Paul, we were providing financial advice to individuals and businesses, and of course the wills and estate planning became part of that. So when we sold that practice some while ago, I continued with the estate planning. And really enjoy that, and helping people to get all their ducks in a row, basically. So a lot of people say, well, what actually is estate planning? It's really formed of lots of different kind of tools that help us get our ducks in a row. So it means that we are basically thinking about what we would want to happen in certain scenarios. And the way that we get this down is through a series of documents. So wills lay out what happens when you die. The wills can include trusts, which give further guidance and control over how you want those affairs managed going into the future. The lasting powers of attorney aren't for when you die, they're for if you don't die, essentially, but if you lack the capacity to act for yourself. So it's giving that authority to people to help you, basically. And like I say, we also do some kind of inheritance tax planning and mitigation as well. So why should you write your will? Well, from a personal perspective, we're going to look at first. So essentially, a will is going to cover four main areas. It's your chance to choose how you want things to go. So who you want to manage those affairs, i.e. the executors, what kind of funeral that you want. Now, a lot of people say to me, oh, I don't mind, I'll be gone. Well, that's exactly the point, is that your executors are going to have to choose that otherwise. And then that means that's where family conflict can start, etc. So we don't want that. Let's get things clear and laid out nicely for our loved ones. Also, with regard to children, naming who you would want to take parental responsibility for them in the event of your death, and ensuring they have a fund of money for their upbringing. And then essentially dealing with all your property and assets, dividing those up as we want. If you don't write a will, then you are deemed to have died intestate. So that means certain rules apply, depending whether you're married, whether you have children, all sorts of criteria. But basically, there's a flow of how it would go. And for many, many people, that is really not what they would want to happen. So really good to just make this simple document and not leave that to chance. So in particular, when should you write a will? Well, really all adults should have a will. And in particular, if you own assets, so that could be your home, or it might be investments, savings. If you have young children, so any children under 18, we need to be defining those guardians, like I mentioned earlier. If you're an unmarried couple, so this is a big one because a lot of people don't get married now. They might live as if they're married, but if they're not technically married or in a civil partnership, they have no rights in the event of death. No such thing as common law. So that's really one to make special note of. If you have children from a previous relationship, so we do get obviously a lot of second marriages these days, and the children are from before, and it's so easy for that other family to become sideways disinherited, and you know, none of us would want that. And the one that we're here to talk about today, if you have shares in a business. So why should you write your will from a business perspective? Well, obviously there are various different ways that you might be a business owner. So looking first of all at sole shareholder director. So obviously a lot of those around these days. I think more people are tending towards this structure perhaps than sole trader. You know, gives limited liability, etc. So yeah, that's often the way. Sorry, I'll zip back to that one. So why should you write your will? Well, we can include sections in the will that are going to give authority to executors to actually deal with that business, because if you're the sole shareholder and director, then there's nobody left officially to actually manage that company. So we need to apply those rights to somebody that you trust. There may well be a sale value of that business, either a goodwill value or, you know, you might have plant and machinery. There could be all sorts of things that might make up a value of that business. And of course, you would want that to that value to go to your family. You would want to make provision for your family potentially through that value. So it gives that authority for people to be able to deal with the company, deal with its sale if appropriate, and recoup those funds for your loved ones. If the business has quite a significant value, it can also be pertinent to think about business property relief. So there is an amount that you can leave in a business that is then not subject to inheritance tax. It will be over and above your kind of normal nil rate band allowances. And obviously, if a business is of a significant value, we want to make sure that we're taking advantage of any allowances there, and also that that allowance is not lost going forward. You know, should you pass the shares to a spouse and then the spouse pass away, that business property relief status might have been lost. And there are some things that we can do to kind of protect that, because when you think about it, inheritance tax is charged at 40%. So that's a significant amount of money that you're giving away there. So if we can avoid that, that's obviously good. The next scenario that I come across quite a lot actually is husband and wife shareholders and directors in the business. So a lot of the similar things apply. You know, if one of the couple died you'd want to make sure that you were providing for the other and any other family members. But of course, husbands and wives travel together, etc., do things together. So there's always a chance, sadly, that something could happen to them kind of at the same time. So we've still got the similar issues to what we have if you're a sole shareholder. And again, it's all about protecting that business and preparing it for sale, such that that value can be returned to family, and things are made much more easy to deal with. It's never going to be a great scenario, winding up or managing a business in the event of death, but let's at least make it so that those people have that ability. So again, that's very similar to the sole shareholder scenario. Where it does get sort of even slightly more complicated, I suppose, is with multiple shareholders. So they might not be related to each other. Say for example, you had four chaps running a business, and their own wives and partners are not part of the business. Obviously, that creates potential for not necessarily conflict, but obviously if one of them were to die, the family wants to get their value of that person's business holding, but the business might not actually be in a position to fund that. So this is where my advice crosses over with, for example, independent financial advisors and accountants, to ensure that if we had, say, as I say, 4 shareholders, one of them passed away, and their shareholding was worth perhaps 250,000, in their will they might have left their shareholding to their spouse, but that spouse may not have anything to do with that business. They might not be qualified to work in the business, and the business might not want to have them as part of it either. So if we look at things like key person insurance, this is a form of life insurance that the business can take out, which would pay out that £250,000 to enable the business to buy back those shares from the family. So it serves 2 purposes. One, the family can have their money, which they may well need to support themselves, and the business gets its shares back, but it hasn't cost them money out of their own cash flow. The insurance has paid out for that, and then it allows that business to kind of carry on going forward, and do the work that it needs to do. So 2 kinds of insurance there. Actually, the shareholder insurance is what enables that to happen, but key person insurance could also be something they could consider, which would pay out an additional amount to help that business recover. So if that shareholder director was, they're obviously a key person in the business, they have their role, it might be that they need to employ a consultant or somebody else to at least transition them through and help that business recover. And the key person insurance would provide funding for that. There's also a lot of considerations with regard to any shareholder agreement that might be in place. So not every business has a shareholder agreement, but it is normally wise to do so. And this is the sort of agreement that can lay out what happens to those shares. Everyone would agree what they wanted to happen in those various scenarios. So they might all say, oh no, I would want my family to receive income from my shareholding instead. Or they might say, actually, no, we need to buy out that family. And so we can all come to those agreements in lifetime and when everything's running smoothly, and get that in place. So a shareholder agreement is definitely a good thing to have, as I'm sure you talk about a lot, Helen. The other thing that I need to make sure is that any key person insurance and shareholder insurance does tie in with what has been specified in that shareholder agreement. So lots of considerations, and tying in with different professionals on their advice as well, because that often would obviously involve the accountant or other business advisors in that process. And again, just touching on the business property relief tax break, again, that could be really important to make sure we maintain that, because if we're talking about multiple shareholders, we might be talking about a much bigger and more valuable business as well. So again, just making sure that we take advantage of the tax, as it stands, which I think nobody wants to pay more than they need to, do they? So the wills and all those trusts that I might advise people on are what would come into play if somebody died. Almost more tricky, really, for the business in particular, is if a shareholder lost capacity. So when I say loses capacity, that could be for a number of reasons. And I suppose we feel that often losing capacity is normally because of something like dementia and old age. But it can actually be for a lot more different reasons. So it could be some kind of accident or illness. Obviously in COVID, we saw a lot of people that were otherwise healthy, taken down and not able to be present and make decisions. Things like stroke, heart attack, obviously, all these kinds of things that are part of our everyday life now, unfortunately, can impact a business hugely. So if you were a sole shareholder or a multiple shareholder, they can have effects. So what can we do about that? Well, so on the personal side, we can make personal lasting powers of attorney. These are documents that basically give somebody or people that we trust the authority to act as if in our voice. So if we couldn't act, they could step in and act on our behalf. Now, this could be in terms of property and money and finances, or it could be with regard to health and welfare and care, including things like life-sustaining treatment. So that's the two main areas for personal lasting power of attorney. Then we also need to consider the business. So with a business lasting power of attorney, it doesn't cover any of the health and welfare aspects, but it can be made to be more specific to the needs of that business. And it might be that the attorneys you choose to act for you might be more specifically to do with the business as well. So they might be other colleagues or another shareholder, for example, that you might want to specify, perhaps alongside a spouse or anything. So that's where I would talk to people about who those people might be. The business lasting power of attorney is really going to give the remaining directors potentially that authority to act. Because I don't know if you're aware that if there's multiple directors and shareholders, if one of them can't act and they can't achieve quorum, so the kind of majority, etc., on decisions, then it very much limits the decisions that the business can make. So obviously, often day-to-day bits can be carried on just under the supervision of one of the directors. But if we're talking about major decisions, and depending what's in the shareholders agreement, then this can get very complicated and can be very limited if one of those directors isn't present. So having this business LPA in place would solve that problem. It would enable that day-to-day running of the business, so keeping that going and managing cash flow, managing finances, etc. It might be that the business might need to recruit some staff or a consultant or something to help out, even temporarily while that person is away, or maybe as an ongoing thing. But often, for a shareholder, It might be just having the ability to maintain that business until the owner returned, especially if it was an accident or something. So it's really all about that protection, and we hope it's never needed. But at least if you've made this document in advance, that just sits there and waits until it's required, and hopefully never is. But if it is needed, at least it's there to use straight away. It takes me about 4 to 6 months to get a lasting power of attorney in place for somebody. So that's why I always recommend thinking about it whilst everything's hunky-dory, while there's no issues, and we can get that sorted out for people. So this is where I come in. Essentially, I offer people a free 30-minute discovery call. So that's either individuals and or business owners. Or business owners are people at the end of the day, aren't they? So there's a strong crossover with personal arrangements and business ones. So in the call, I'll be able to find out a bit more about them and start to give them bespoke advice as to what they should be thinking about. We can have meetings where I would guide them through the different choices, depending on knowing their family setup, etc., the business setup, all of that, and taking that right the way through to them having properly signed and registered documents in place and tucked away so that when they're needed, they can be retrieved from the secure system. So that's me, Dawn from South Downs Legacy, and hopefully that's been a useful overview of everything. A little dry, I'm sure, but it's important stuff, isn't it?
Very thought-provoking. Plus, I enjoyed every so often seeing the dog behind your slides. That just, add an extra
Oh, is
level.
that right? Did it?
No, it's good. I like that. It's a bit like, oh yeah, there's a puppy there.
Asleep in a chair.
Exactly. That's what mine's doing, having done many other things in the space of you talking. He's now asleep in a chair. Really, really thought-provoking and really, really important topic, because I do think this is a topic that most people don't want to think about. They don't, again, until they need to think about it. I think it's so important just to think, just to highlight this. Plus, I think the specifics of thinking about this for your business are an extra layer that a lot of people wouldn't think about. I know, for example, my husband and I have got a will. We still haven't done our lasting power of attorney because that just proved a little bit too challenging for us for technical reasons. But we've got a will, but then I've set up the business since then. So it's kind of, that process of making sure everything's still in place. And it's still fit for purpose. And I think that's an important point as well, isn't it? Yes, once you've done it, you're at least in a better place, but you also need to look at it when all these different things that can happen in your life will impact this.
Yeah.
So you need to bear that in mind.
Things that change every year.
Things change, yeah. You need to look at it, don't you, with frequency, like you would do anything else that's kind of about.
Yeah, and that's what I encourage people to do is just, have a read. If we've done all this and we've put it all in place, then I'll give them a little prompter each year to make sure they read through everything, just sense check it. The amount of people I've said, I've spoken to that have said, oh, we have wills, it's all fine. And then when I encourage them to read through, they've perhaps only named one of their children and they've had 2 more since, or, and that's so common. So, yeah, and it's so easily avoided. That's the thing. But I can at least make that conversation guided such that we cover off everything that might be relevant to their circumstances and make it hopefully cheerful and somewhat peacemaking, if you like, such that
I just had a couple of questions, if that's all right.
Of course, Sarah.
So one question is, can anybody be an LPA? And if there is a sort of like job description, who would you sort of recommend to be an LPA in an ideal world? And the second question is, if you have a will that's already existence and sits with a solicitor firm at the minute, and you want to make some changes, can you easily transfer from that firm and give that business to somebody else and they kind of pick up the old will and then make the amendments? Or is it best to kind of keep everything in the same place just for, I suppose, ease?
Yeah, okay. So let's address that one first. Yep. So if you've made a will and it's stored with a particular firm, you know, that's absolutely fine. I would just suggest read through the copy that you should have, and if it's out of date and anything needs changing, then yeah, you can either go to somebody else and they can start again. So I would never make an amendment to somebody else's will, because effectively I'm endorsing that will, so that would come then under my insurance. So I would always start from scratch, go through things again with you to make sure that it actually is what you think. So it's a personal preference. You can either do that, or you could go back to the firm that had written it, and then they would give you a price for doing a codicil or something like that. Sometimes if you're with a solicitor firm, it can be sometimes just as expensive to get a codicil as to starting again with me, to be fair, but yeah, we could always have a discovery call to establish that. So going back to your other question about lasting power of attorney, so who to choose as your attorney is, yeah, it's sometimes a tricky one. So obviously if you are married or with a long-term partner, then that might be the obvious choice. Or if you have adult children, they could also be chosen. So you can have up to 4 attorneys at that first level, and they can all act for you. Somebody that knows you quite well, somebody that is, there's 2 kinds. There's property and financial affairs, and there's health and welfare. So you might choose somebody that you're close to for health and welfare, but the person that you would want to manage your finances, which could include the business, might be somebody that's more financially minded. It can be separate people. Quite often for people it's the same set of people, but when we come to businesses, the attorneys may well be somebody else in the business, because it obviously would make sense for them to understand and know the business, and yeah, be able to do the things that they're used to doing or supporting you with. So that would be part of my discussion and advice anyway.
Great, thank you.
It's all right.
Thank you for that, Sarah. And I think just one question that was going through my mind, Dawn, as you were talking about it, which I probably know the answer to, but I'm still going to ask it just in case I'm wrong.
Right.
I don't like making assumptions. So within the lasting power of attorney world, I'm going to call it that. So there obviously are the sort of things you make, whether it's your health, your finances, that you would make as an individual. Would they automatically cover a business if you don't go to, whether you're doing a formal business power lasting attorney, and let's say it's between you and your husband generally, as an example, or is it still the right thing to have in place, think lasting power of attorneys that cover sort of the personal
Separate
elements of your
business.
life and then separate for your business?
Yeah, so generally speaking, yes, it is a good idea to have them separate. It can just make it easier logistically, even if that person is one in the same. However, if you only made a personal property and finance LPA, it would automatically cover your business unless you did something else.
Right.
So yeah.
Okay.
So it can just make it clearer to have them 2 separate, because you can provide other preferences and instructions that might be different to what you would want as a personal issue. Yeah.
Yes. Yeah, I can understand that. Yeah, because it's not automatic just because your partner is a director that they're actually that involved in your business or would want anything to do with it. So you would need to just put something in place.
They might be involved, in which case they would be the ideal person potentially, but they might not be at all involved in the business, and therefore yeah, you might want somebody that's more in your industry, shall we say.
Yes, indeed. Yeah. Good point. Okay. That's really helpful. That has given me much food for thought, as always.
I do tend to find that with my presentations, people have more questions than they had before.
It is. It's always the thing, is, because it is the thing that we all know we should do, as I said, and we put it off. And I think it's really, again, it's a really important, like with anything else I would say to anyone else I talk to, the more you plan, the better things are going to be. And this is just one other element of your life and your business that you should be planning, and be in charge of. No, don't wait for unfortunate things to happen, and then it's being done for you because you did not make your decisions. And you didn't,
or it can't be done for you because you haven't given that authority. And therefore then the business is kind of stuck, or your personal arrangements are stuck, or have to go through a much more expensive route, are often the options. So
it's a very important thing to take away, definitely.
Really I'm glad it was useful.
Very useful. Any final questions? Okay, well, Dawn, thank you so much. As I say, really appreciate you coming today, and I really appreciate you sharing that. I'm just going to share one last thing myself. Try and share my screen. Let me do that. So just as we close out today's session, thank you everybody for joining today. Always a really good session, and really valuable thing to be thinking about. Our next session will be in March, and it is scheduled for, I want to say, the 19th of March, but I need to double check that. So I believe it's scheduled for the 19th of March because I'm not available on the normal date. And I'm going to be talking about my new framework for resilience in that session. So this is a distilling of my expertise and experience, and really trying to come up with something that it's not actually new, it's the way I've been doing this all along, but I'm now giving it a structure and a format. So that's next month's event, and if you use the QR code you can sign up for that.
Great, thank you.
Thank you as always, and really appreciate everyone joining.
Thanks, Helen.
Thank you very much, Helen. Really useful.
Thank you.
Thanks. Take care.